Did you get your green card through marriage and now you're getting divorced? Don't panic. Divorce doesn't automatically mean deportation. Hi, if you don't know me, my name is Remzi Kulen. I'm an immigration attorney with an experience of more than 20 years helping individuals and families secure their green cards and navigate through the complex immigration law system in the US. One of the most common and emotional questions I get is this: I got my green card through marriage, now I'm getting divorced. Am I going to lose my green card? Divorce is already stressful. When immigration and legal status is involved, the fear and uncertainty can be overwhelming. Many people incorrectly assume that when the marriage is over, their green card status will end and they will have to depart the US. This is not true. Today, I want to talk to you about what really happens when the marriage which gave you the green card ends, what factors matter the most, and what options may still be available to you. Understanding the immigration law in this aspect is very important in knowing what your options are and how you're going to take an action. First, it's important to clear up a major misconception. US immigration law does not require a marriage to last forever. What it requires is the marriage was real and it was entered into good faith with a goal to establish a life together. So USCIS is not asking whether a relationship has worked out or not. They're asking whether you entered the marriage in good faith. That distinction is real. Whether you entered into this marriage with a goal to establish a life together, whether you really intended to be a couple living together. What happens after divorce depends largely on what kind of green card you have and when the divorce occurs. When someone receives a green card through marriage to a green card holder or a US citizen spouse, you get one of the two cards. You receive a 10-year permanent green card, or you receive a 2-year conditional green card. The difference between the two determines what your next steps are going to be after the divorce. When you have a 10-year permanent green card, the divorce does not affect your legal status at all. You may remain in the United States, work legally, travel, renew your green card when it expires, and apply for US citizenship in the future. However, divorce can affect when you are eligible for naturalization. For example, if you were planning to apply for naturalization after 3 years of having a green card, and if you got divorced, now you need to wait for 5 years as a lawful permanent resident to be able to file for naturalization. Even in this situation, details matter. How you entered into marriage, if there are any prior inconsistencies in your applications, whether you had prior interviews. Any questions about marriage can still cause problems if not handled properly. For example, in your naturalization application, you may be asked questions about your marriage, whether you entered into this marriage in good faith, and how the marriage ended. So although you have a 10-year permanent resident card, you may still be asked questions about this marriage at the naturalization interview. If you have a 2-year conditional resident card and the divorce happens, this is where people really become worried, and rightfully so. A 2-year conditional green card is issued when the marriage is less than 2 years old at the time of the granting of the green card. So if you went to your interview and your marriage is more than 2 years old, once you get the green card, it will be a 10-year green card. If your green card is approved when the marriage was less than 2 years old, then the green card will be a 2-year conditional green card. What that means is before the card expires, the couple needs to file a form called I-751 to remove the conditions of the green card and receive the permanent 10-year green card. Yes, you have to file it with your spouse, but what if the marriage ended, the divorce happened before the end of the 2-year period? The good news is this: divorce does not automatically qualify you, so you still have to file the 751, but this time you need to file it on your own. This is called waiver of the joint filing requirement. So even after the divorce, you can file the I-751 form on your own, and you are qualified to get the 10-year green card if you can show the following. The marriage was entered into in good faith, you intended to build a life together, and the relationship was genuine even if it later failed. USCIS understands that marriages end for a variety of reasons: cultural differences, financial stress, abuse, infidelity, or simply growing apart. What they care about is the intent at the beginning, not the ending. So if you were to file a 751 on your own, what matters the most is the evidence. Evidence is the king in these applications. Your evidence may include anything that shows a joint life together. For example, you may have apartment leases showing both of your names on the lease agreement. You may have shared joint bank accounts or credit card statements. You may have insurance together. This could be health insurance, this could be car insurance, It could be life insurance. Photos are very important throughout the marriage. I always advise couples to take as many photos as they can, even though they don't like taking photos a lot. Messages or correspondence between couple. Affidavits from friends or family who can attest to the fact that this was a marriage entered into in good faith but then later deteriorated. If the couple has a child, birth certificates are very important to show common children together. A weak or poorly filed case can lead to requests for evidence, lengthy delays, interviews, denials, or even placement into removal proceedings after the 751 denial. I always advise my clients and my followers to make sure you retain a really good, qualified, experienced immigration lawyer to file a 751 if you are filing it alone. It is very important to file this application on time and properly. Many people ask if they have to wait for the divorce to be final to be able to file the 751 application. The answer depends on timing, strategy, and the jurisdiction. What you cannot do is not file the 751 before the end of the 2-year on the conditional green card. You definitely need to file it even if the divorce is not finalized. Of course, it is advisable to finalize the divorce and then file the application, but you can never miss the deadline on the 2-year green card. In some instances, it may be advisable to file the case while the divorce application is pending. In such circumstances, usually USCIS sends you a request for evidence to submit the finalized divorce decision from the court later. Filing too early or too late may become a real problem in your case, so deciding on when to file the application is crucial. So this is where the legal advice becomes really essential. What if there was abuse or extreme hardship in the marriage? In these instances, additional legal remedies may be available. If you are separated from your U.S. citizen spouse due to abuse, this should be clearly stated in your I-751 application. In abuse-based I-751 applications, USCIS may even waive the filing fee. It is extremely important to prove the abuse with evidence in your application. It is not merely claiming that you were abused is not sufficient. You have to have evidence of it. The strength of your documentation can significantly impact the outcome of your case. If the marriage involves physical or psychological abuse, extreme cruelty, or if removal from the US will cause extreme hardship to you, there may be separate waiver options available to you. These cases are extremely sensitive and requires careful, strategic, and thorough documentation. Because these protections exist for an important reason: to safeguard vulnerable individuals. In many instances, I hear clients coming to me and saying, my US citizen spouse is telling me that he will report me to the USCIS. If you entered the marriage in good faith, you shouldn't be worried about this, because USCIS gets these kinds of complaints all the time. But if it is coming from a spouse who is just doing this to get back at you, meaning you entered into good marriage, but now since the divorce is on the table, your spouse wants to get a revenge from you, USCIS will not consider this. So you should never stay in a marriage if you're not happy and if it's not working out, as long as you entered into marriage in good faith. In these circumstances, family attorneys and immigration attorneys work hand in hand to protect you and your rights. But don't forget, you should never stay in a marriage just because you want to get the green card. Because, like I said, what is important is what happened while you were entering into the marriage, whether you had good faith during that time. So divorce does not end your life automatically in the United States. But how you respond during the divorce proceedings or after the divorce can determine whether you can stay in the US or face serious immigration consequences. And do not ever forget, every case is different. Just because something happened to your friend does not mean it will automatically happen to you. Consult with an experienced immigration attorney. Small mistakes can have permanent consequences, and you cannot generally undo what's done in immigration. Every little legal advice can protect your status, your work authorization, and your future. And the advice you should get is from an immigration attorney, not from a friend. If you are facing divorce or difficulty in marriage and you have a marriage-based green card, especially a conditional one, do not wait until the last minute to get legal advice. Act, be proactive, and get the legal advice as soon as you can. In closing, divorce is never easy, but if your immigration status is also involved in this picture, then it may be overwhelming. But understanding your rights and options is the first step towards protecting your future. I can happily say I've helped hundreds of people filing 751 applications while they are going through divorce proceedings and everyone ended very happily. And each one of them ended keeping the green card because they entered into marriage in good faith. And we were able to prove that. If you found this video helpful, please subscribe to the channel and like the video so that others can see it. We regularly share immigration updates, legal guidance, and answers to the questions our clients ask us all the time. And if you're facing a situation like this and you need legal advice, speak with an experienced immigration attorney before taking any action. Thank you for watching.